you plead to that? True or not true?
True.
The court calls the case of Christopher Scott Jones. He admits to violating Condition 19 by contacting Scarlett Jones, despite a strict no-contact order from his assault family violence case. The judge questions why he ignored the rule, emphasizing the seriousness of protective orders and the danger of repeated violations.
And then, Your Honor, the state will waive and abandon the others.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 19, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 19? Court will find violation of condition number 19 true. The court will let both parties know. The court has received these documents in the court's file. I have not read them because I don't read anything until both parties have had a chance to view them and have any objections to them.
Absolutely, Your Honor.
So have you all both had a chance to review the documents that are sent to the court's file?
I have not, Your Honor.
Those are the ones from last year.
Okay, those are the ones we talked about last time.
That's exactly right. Yeah, there's nothing new. Those are from, nothing from the past like week or two, correct, Your Honor? Those
No.
are, no, so yes, I believe counsel and I have reviewed them in depth, all of them together.
All right. And would you like the court to read these, counsel, or do you have objections?
Essentially, Judge, they're hearsay, but I know the court can consider that.
Well, I mean,
Defense proposes house arrest, GPS monitoring, and counseling, but the judge is unconvinced. She stresses that Jones continues contacting someone who explicitly doesn't want him around, showing he hasn't accepted boundaries. Because this is his second family violence incident, the judge decides probation is no longer appropriate and revokes it.
well, I mean, if you all have objections to it, then I won't read them. They are hearsay.
I'd object.
All right. All right. So if the witnesses are not here for the court to read those, then the objection will be sustained.
Thank you.
All right. So is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance. House
A
arrest
separate hearing addresses personal property from another defendant. Items like wallets, IDs, and clothing will be returned only after being photographed and documented. In another case, the court reviews a defendant rejected from felony drug court. The judge warns if he tests positive even once, probation will be revoked.
house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in VIP within 15 days of release.
All right. And who is Scarlett Jones, and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated within the.
Everyone, please whisper.
I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right. Is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
Okay.
Same person, Judge.
All right. Same person. So I ordered.
No, Scarlett Jones is my wife in the movie.
Okay. Scarlett Jones is Mr. Jones' wife.
All right. And who is Sydney Jones?
My daughter.
All right. And Scarlett Jones. Okay. The court ordered no contact with Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The council may know.
Yes.
Ruby, who's that?
No, Scarlett Jones is the person he pled true to the number 19 violation.
Yes.
And I ordered no contact with that person.
Understood.
So I want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced. We have new paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding is that he had gone by and he is struggling mentally to try to let go of what this relationship was. He misses his kids, he misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he?
Who?
How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right, so I don't understand what he doesn't understand, that the court ordered a no contact order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I totally respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse, but I'm just I think that's the reality of what happened. Nobody was harmed. Nobody was, I don't believe in it. Nothing happened from the contact. I'm trying to get this guy back on track.
Yeah, but this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense, and we probably wouldn't be here, and maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for about 60 days now. He's going to have another 30 on house arrest. He's going to be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth, and that if he violates that, it's not just an MTR next time. He's going to be back in here on a violation of a protective order.
Oh, but my rulings have teeth, and my ruling was
absolutely
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger
I
management?
enrolled in the PIP. I did 5 classes of PIP so far.
Probation, has he done anything?
Judge, he was granted probation in November. He submitted a negative delay in December. I don't have any indication that any of his classes have been complete. He did pay a total of $190 for his assessed fines and fees.
All right. Is there anything else?
No, Your Honor, and if the court would like to as well, like I said, not a state's file, like me creating a separate thing in a different file chart. I had to draft out the relationships. It's like a whole page of who interacts with who. So if the court, if I could better explain, I would. I have that information. I don't have it with me. It wasn't.
Oh, no problem. The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. He probably would still be in a relationship with her with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful in this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. Explain it to him. And if he comes back.
All right, the court is finding violation of condition number 19 true. The court is going to find him guilty. That is an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish to speak to punishment?
Your Honor, I understand the court's ruling. I think that given the facts and circumstances here, and the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family, and I don't see him going by there at all. We would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this, a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just ask the court to consider this the minimum on this case.
State.
And then, Your Honor, the state, about 10 seconds, Your Honor, the state is accessing the legacy system just to get a better handle on the Bear County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor. And that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding of family violence. Give you credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and signed it?
Yes, ma'am.
All right. Do you have a limited right to appeal? And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I want you to know, I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Good luck to you. We're going to go on the record. Court is calling NIMAG number 758930, State of Texas versus Marlon Daniels. Can I have parties announced for the record for the state?
Jason Garrett, hand on.
Defense?
George Sherman on behalf of the defendant.
And are you Marlon Daniels?
Yes, ma'am.
All right. Defense has filed a motion for release of personal property. State, have you a chance to review that?
I reviewed it last week, yeah.
All right. Any objections?
Yes, Your Honor. At this time, it's just, in just abundance of caution, the state has not reviewed the possible items that would be returned. I know that there's some identifying papers, and there's other objects that we may not be opposed to necessarily. I believe Mr. Sharman said something about a scooter of some sort for
All right.
getting around.
Let me go through the list and you just tell me what you have objections to, then I'll hear it. All right. His wallet.
Objection.
All right. And what is the state's objections to him receiving his wallet back?
Identification purposes, Your Honor, for him being in the vehicle.
All right. So is it possible for parties to make a copy of the items that are in the wallet, make a copy of his driver's license, make a copy of the VA documents, have the defendant and defense sign off to the fact that these are copies of the wallet, the driver's license, and the VA documents that were in the vehicle?
I'd be fine with that, Judge,
Yes, that's fine with the state.
All right.
as long as we can do it soon.
Well, that's something you all have to work out
Okay.
amongst each other. So the wallet, the driver's license, and the VA documents will be returned once the state has made copies of those. Mr. Daniels, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, ma'am.
You can lower your hand.
Thank you.
So you understand the wallet, the driver's license, and the VA documents will be returned to you once the state is able to make copies of those documents?
Yes, ma'am.
And you understand that your attorney has agreed that you will sign a document stating that the copies the state will make of the wallet, the driver's license, and the VA documents. You will sign a document stating that those documents, the originals, came from the vehicle, whatever part of the vehicle, and that you agree that they will have been found in that specific place.
Yes, ma'am.
All right. Personal documents.
I don't know what the personal documents are.
Badge that you.
What are the personal documents?
Garage door opener, key card for work.
All right, just 1 second. Let's slow it down.
Right now.
So the garage door opener,
Key card for work.
key card for work,
And there's a gym bag and it has a miscellaneous items in it.
gym bag. Well, here's the thing. We have to be very specific.
Okay.
What's in the gym bag?
Probably pencils, pen, an air pump.
All right, so with regards to the gym bag, the court is not going to agree to release that to you until people have had a chance to view what's in the gym bag.
Okay.
All right. Garage door opener. Any objections? Okay. Key card from work.
Maybe just a copy of it, Judge. I don't know if it has a photo ID or anything.
All right. So the key card from work.
It doesn't have photo ID, ma'am. It's just a regular,
All right. So what we'll do is the state will make a copy. Both defense and you will agree that that is a copy of the original that came from the vehicle. All right. So those will be released. Air pump.
So for basketball or something. Sort.
What is the air pump?
the air pump was basically for when I have flat tires, emergency purposes.
No objections to that.
Okay. Clothing.
I had two jackets, winter jackets, one hoodie, they're both hoodies. One's a zip up hoodie.
Winter jacket and hoodie. State, is that an item that you all can have somebody take photos of?
That's what I was going to suggest, Your Honor. Just we can take photos of those items.
All right, so they're going to take photos of those items. And again, counsel, and you will stipulate that those items were found in the vehicle?
No problem, ma'am.
Okay.
Sorry.
Documentation from glove box.
I believe it's an owner manual. Might be a measuring tape, tire gauge, maybe registration and license, not license, but insurance paperwork. Can't think of anything else that might be in there.
All right, the owner manual.
We'd like that to stay with the vehicle.
All right, so the owner manual is going to stay with the vehicle because really, what can you do with an owner manual if you don't have the vehicle? With regards to the measuring tape,
No objection.
okay. Tire gauge,
No objection.
registration, insurance, and paperwork copies.
We'd like to at least keep that with the court. I'm sorry, with the vehicle, or at least make copies.
All right. So with that, there will be copies. Sir, are you okay?
Just breathing right now, ma'am.
Okay. Do you need to have a seat?
I think I'll be fine.
Just 1 second. Deputy Laura, we're going to get him a seat.
There he is.
All right. Yes, let him have, sir, have a seat.
Thank you.
And just take deep breaths. Do we need to call somebody for you?
No, I should be fine, ma'am. Just hyperventilating.
All right. Do you need any water?
Yes, please.
I thought I had a bottle.
Why not, please, on record.
Could somebody see, do we have cups in the back to get him some water? All right. Thank you.
I guess I'm pretty sure.